this session and not in a sleep mode. So Saturday sessions are a bit difficult. We are at home generally, and it's difficult to concentrate after lunch. But today is a bit different. We have all had our coffees of the noon, and we are back from the coma, which comes with lunch. So this is regarding something a very interesting topic, which is there in the air, but which has not yet landed in India. Somehow, somewhere in this monsoon session, also there was a news that this was being tabled and this was going to be the reality very soon. Group insolvency, cross-border insolvency, all of them were to come. By now, we would have been discussing, we would have been seeing them in the newspaper highlights. But unfortunately, this is still deferred and delayed by the government. The drafts are not yet ready. Drafts shall be circulated in the public with the stakeholders. They shall give their views, comments, and the discussions shall happen thereafter. And then only it shall be tabled for any amendment to the IBC. It's a long drawn process, and I'm sure we are on the verge of starting that process of amendment. So very soon, after 2021, April 2021 was the last amendment, and very soon we are going to see the amendment in IBC with respect to a major change, that is cross-border insolvency, and why the institutes and why the IPAs and the IBBI is so keen on our IPs to be equipped with the concept prior to the launch of cross-border insolvency. You will just see in the presentation that I have for you, that is based on the available information and the model law, right? So we will see what all these are and where we are, what we need to understand prior to the launch of the this cross-border insolvency becoming a law, becoming a reality for us. All right, so screen is visible. Shall I
Yes,
start? All right.
it is.
So thank you so much.
Yes,
So
madam, it is visible.
thank you. So first of all, as a concept, why we need to know the concept? Because when it will become a reality, they'll in no time we'll be working on the cases along with the law thereon. So it's important that we understand why and where this comes from. So it's not about only having some insolvency matters being dealt with in two countries. That is yes, but why that situation arises? Why insolvency is happening in two countries at the same time? Why that complication? That complication comes when a company either has assets in two countries, debtors in two countries, creditors in two countries, operations in two countries, or other interest in two countries, right? Promoters may be lying in two countries, although that does not usually happen, but operations being managed at two different places, assets being managed at different places, creditors being managed, being there at two different countries, it is very much possible. So we will see all the contours, how and how this situation shall be dealt with when there is an insolvency situation in the company, right? Company may be one entity, but it may be having its operations elsewhere. So how that situation shall be dealt with in case an insolvency situation occurs. So problem comes in when the law has to be decided, which law shall be chosen, which uh, court shall have a jurisdiction on the matter, which rules, jurisdiction, judgment rules shall be applicable or not applicable. For example, maybe Norway has decided something, or the Netherlands has decided something. Will that be applicable in India or not? So such intricate questions keep coming, and their answers lie in the domestic laws. International laws are very clear, but we have not yet adopted them to make them our own law. So it is under the process of customization, and we will see where we are. So as per Professor Fletcher, cross-border insolvency refers to instances in which insolvency circumstances cross the borders of a single legal system and where the provisions of domestic insolvency law cannot be applied without taking into account the issues raised by the foreign elements of the case. There used to be a Gibbs law, Gibbs rule it used to be called, and it is not at all in synchronization with the present requirements, with the contemporary approach, with the universalization of the activities. So in this rule, earlier, prior to the model law, what used to happen is for example, the main principle was a discharge of any debt or liability under the bankruptcy law of a foreign jurisdiction is a discharge therefrom in England. It was based out of England. If and only if it is a discharge under the law applicable to the contract. So whatever law was applicable to that contract, that country would be ruling in that country would be prevailing. Similarly, a foreign composition under a scheme of arrangement would not be regarded as effective unless it operates as a discharge according to the law of the debt. So there, it is complicated and it is one-sided. It does not take into account the universal aspect of operations which we are operating now these days. So it has also failed to recognize, to address the globalized nature, and the companies, as you know, we are multinational companies. We are having multinational operations and all that sort. So I'm not getting into details of where we are today because this is known to us. Here, one thing is very important: principle of collectivity. So principle of collectivity refers to looking at its entity from the macro level, and where all it is having operations shall be looked at from one entity concept. So that is called principle of collectivity, which was brutally ignored in the Gibbs rule. So that has to be ignored. That can now no longer be applicable in the cross-border transactions now. And what to say about cross-border insolvency? Simple cross-border transactions are subject to so many bilateral agreements, terms and conditions thereof, domestic countries, rules, regulations, etc. So what about the insolvency case? When the company is itself in distress, some assets are available, some have gone by. So all that has to be taken care of. So the bill, as I've told you, was to be kept in this monsoon session. But since the MCA has not yet prepared the final bill for discussion, which is usually usually sends to the stakeholders for their comments, that draft is not ready. So it has again been deferred. Prior, what all amendments are being expected in the in this amendment to the IBC, what all amendments are expected in this bill this time. One is a cross-border insolvency. One, the prior approval of CCI may not be now kept mandatory for a resolution plan in case there are mergers or combinations happening through that plan. Introduction of group insolvency shall be allowed formally now. Earlier, it has been done on an experimental basis by the courts. Cross-border insolvency to provide a structured mechanism in dealing with the bankruptcy cases across the countries. Creditor-led resolution process. This is very interesting, and this is going to come, that will allow creditor-driven out-of-court settlements. This will be a little extension to the PPIRP, and they are trying to make PPIRP successful in India also, as it is already very successful in the US and UK. Modification in the 14 days timeline for admission of applications, which is practically, which has not been a single case which has been admitted within 14 days. So that mandatory application shall be changed, and equitable treatment for operational creditors with financial creditors. So that might be an amendment. So these are the amendments expected now. What has happened in India till now for cross-border insolvency? In October 2018, the ILC, that is Insolvency Law Committee, submitted a report on cross-border insolvency to the MCA. This report recommended the adoption of UNCITRAL model law on cross-border insolvency as a part of IBC 2016. MCA-wide public notice dated 20th June 2018 drafted Part Z of the IBC that has already been drafted, which is the overview of cross-border insolvency framework for corporate debtors under IBC for suggestions. The report on the rules and regulations was also prepared by the Cross-Border Insolvency Rules or Regulations Committee by MCA. So this is still at the draft stage, and no further changes have been made to this. A further draft is expected from MCA very soon, which shall be open to all the stakeholders for discussion and comments, and thereafter an amendment to the IBC shall be made. But we are very close to the closure. What is there in the IBC at present? How do you think we look at the cross-border transactions right now? We have section 234, which talks about agreements with the foreign countries, but this has a prerequisite of reciprocal arrangement or the bilateral agreements, as we call it. The section says the central government may enter into an agreement with the government of any country outside India for enforcing the provisions of this code, right? The central government may, by notification in the official gazette, direct that the application of provisions of IBC in relation to the assets or property of a CD or debtor. See, they are planning to include the individual also in this capacity, including a personal guarantor of a CD, as the case may be. So CD, an individual person debtor, a personal guarantor, all of them are covered in this. Situated at any place in a country outside India, with which reciprocal arrangements have been made. So reciprocal arrangements have to be there for the application of this section 234. And since those arrangements are not there, so this 234 is not yet applicable, and the central government cannot decide upon or dictate terms and conditions for dealing with such insolvency or such assets which are belonging to, which are situated or located in the other countries. So important is that central government may, by notification, direct that these assets or property shall be subject to such conditions as may be specified. So such conditions shall be specified in the regulations related to the cross-border insolvency, which is already there. June 2020, a draft of regulations was also prepared by MCA, but that is still not in, has not seen the light of the day. Most of us have not gone through it. I have only read the October 2018 Part Z of the IBC, which is at the draft stage. I have not yet gone through the rules and regulations made thereunder, which were published in 2020. So let us see when the right time comes, we'll start reading them all together. Another section in the existing IBC talks about it. It says letter of request to a country outside India in certain cases. It starts with that own sweet non-obstante clause. It says, notwithstanding anything contained in this code or any other law for the timing in force. So this is a powerful section, similar to 238, similar to 53. This is a powerful section. If in the course of insolvency resolution process or liquidation or bankruptcy proceedings, as the case may be, under this code, the RP liquidator or the BT, as the case may be, is of the opinion that the assets of the CD or the debtor here is an individual debtor, including a PG, are situated in a country outside India with which reciprocal arrangements have been made. Again, they are relying on the reciprocal arrangements, that is a bilateral agreements to be in place already. Then the RP liquidator or the BT may make an application to the AA that evidence or action relating to such assets is required in connection with such process or proceeding. So he can only write to a country outside India. A letter of request can be written only when a reciprocal arrangement is there and the central government has in section 234 directed with some conditions regarding to relating to that country. So since that is not there, 235 is also not operational. Subsection 2 says the AA on receipt of an application under subsection 1 and on being satisfied that evidence or action relating to assets, whatever he has requested by the RP or the liquidator or the BT in connection with the insolvency resolution process or liquidation or bankruptcy proceeding, may issue a letter of request to a court or authority of such country competent to deal with such request. So the country RP has recognized and the letter of request shall be issued by our AA to the competent court or whichever shall be the adjudicating authority in that country. So, what is the problem with the existing laws where we are lacking? We are, of course, we are lacking in the reciprocal arrangements that are not there as yet. But uh, even if we have them, do you think these are the foolproof methods of dealing with the situation? Simply writing to them and they shall be handing over the assets to us? No. So problem lies elsewhere. The establishment of uniform bilateral arrangement reduces load on the courts. Understood. However, the effort to negotiate different deals with different countries is a lengthy and cumbersome process, which may require some trade-off, some compromises by us as well. So therefore, this is taking so much of time, and there is no standard procedure. That it is not. It's going to be uniform. It will be different with the different countries. In addition, different agreements with different countries could create differences in standard. This shall make the cross-border insolvency environment uncertain. Every time we will enter into such a situation, the results shall be unknown and not predictable. The development of cross-border insolvency laws in India has been considerably influenced by the judgments in the absence of statutes till now. So those judgments will have to be disregarded now onwards when the law shall be sure and will be in place. So there shall be some complications initially on how we shall be implementing this. What is there in the existing laws otherwise? The provisions of civil procedure, the Code of Civil Procedure, which serves as the primary legal basis for recognizing foreign judgments in India. Section 13 of this outlines the conditions under which foreign judgments can be recognized and enforced in India. And Section 44A provides for a mechanism for executing decrees from reciprocating territories only. Again, the reciprocating territories with which we have a bilateral agreement already, allowing enforcement as if delivered by the domestic courts. Foreign judgment recognition and insolvency proceeding raises several legal questions that are particularly complex in the context of insolvencies involving more than one country. So existing law only supports two things. One is the recognition of the foreign judgment, and section 44A says, there is a proper procedure mechanism for enforcing a decree if it is passed by the foreign country, foreign territory, which is already a reciprocating one with India, right? So there are no provisions about how a proceeding shall run, how an insolvency resolution process shall run. Why, what do we expect in a cross-border framework? What all are the requirements? So there should be some level of cooperation between the adjudicating authorities of the two different countries. Maybe three countries are involved, liquidators thereof, the administrators thereof, the companies involved, and the other stakeholders thereof. There has to be a coordination and cooperation. That is the most important principle. It facilitates greater legal certainty for trade and investment. Third, the framework aims to provide a fair and efficient administration, the running of the process, the running of the insolvency resolution process. Fourth, it aims to facilitate the rescue of financially troubled businesses. Then the coordination, as we have discussed, the lack of coordination can be avoided if there are formal guidelines that set timelines, code of conduct, and facilitate greater communication between the different stakeholders who belong to different countries and on whom different laws are applicable. Insolvency Law Committee ने क्या बताया था? They said this process is an ad hoc framework that is vulnerable to delays and uncertainty for creditors, debtors, and courts. In this backdrop, ILC suggested the adoption of UNCITRAL model law of cross-border insolvency, which was propagated in 1997 by the UNCITRAL with necessary modification to suit the Indian context. The model law has till now been adopted by 60 countries covering 63 jurisdictions in a widely accepted legal framework for cross-border insolvency issues. The membership of what is UNCITRAL? I hope all of you are aware about this. UNCITRAL membership is generally determined by UN General Assembly. The original membership comprised only 29 member states of the UN, but this number was expanded to 36 in 1973, and thereafter it grew to 60 states, and now total 70 member states are there, determined by the UNGA. But out of them, only 60 have adopted, but that's a huge number. And we have not yet adopted the model law. But since we are part of UNCITRAL, we will have to adopt a system very soon. 35 states represent a variety of legal traditions and level of economic development. Again, about UNCITRAL, a subsidiary body of UNGA. It was established in 1966 with the core legal body of UN system in the field of international trade and law. So UNCITRAL looks after many commercial laws across the world, and it helps resolving issues in the international trade and law associated with that business. The official function of UNCITRAL is to modernize and harmonize the rules of international businesses. The organization is responsible for helping to facilitate international trade and investment. It is headquartered in New York with annual sessions held alternatively in Vienna, that is Austria. What are the other laws governed by UNCITRAL? They are dispute resolution, international contract practices, transport, insolvency, electronic commerce, international payments, secure transactions, procurement, the sale of goods, etc. So all of them have a dedicated law in itself, and that has been laid down by UNCITRAL, and the member countries usually adopt the same. Like we have adopted the ADR system directly from them. Insurance is from them. What else ILC report said? It said that the foreign courts or representatives have sought assistance in India in connection with a foreign proceeding. How and where the cross-border insolvency shall affect us. Where any foreign court or foreign liquidator or RP has sought an assistance in India regarding the foreign proceeding. Assistance is sought by us in a foreign country in connection with the proceeding in the IBC going on here. Foreign proceeding and a proceeding in IBC are taking place concurrently, or where the foreign creditors have an interest in requesting commencement of proceeding under the IBC. That has also happened already, you know. Foreign creditors have, in Baiju matter, we are very clearly aware, and in some other matters also, foreign creditors have initiated IBC in India, and we have recognized them as the creditors of the CD situated in India. And IBC proceedings did properly recognize them for the purpose of Section 7 and 9. The model law provides a broad framework, and it is left to the individual jurisdictions to decide operational details to suit their interests. So it is the model law, वो आपको क्या करते हैं, पूरा word document दे देते हैं, and you have to make the tweaks, and you have to make it suitable. You have to customize it as per your own requirements, and you make it suitable to your own country, because you are aware how your country operates. In October 2018, what the MCA prepared was the draft Part Z that incorporates elements from model law already to provide an effective mechanism for dealing with the cross-border insolvency matters. It is based on the principles of access to the foreign and domestic courts in by resolution professionals, recognition of foreign proceedings, cooperation between the courts, coordination of two or more concurrent insolvency proceedings, and there is also another very important, relief. So there are 5 principles: access, recognition, cooperation, coordination, and relief. Relief can be asked in terms of getting the assets transferred to my country, or any kind of relief can be sought, for which Section 234 also supports. The letter of request, sorry, 235 supports that relief. So ultimately, we are asking for some relief, right? Apart from the coordination and cooperation, we are also asking some relief. So that letter of request, our courts can issue to the foreign country directly based on the reciprocal arrangement, and that shall be applicable only once we will have these systems in place. The entire law shall be laid down. Model law is the most widely accepted legal framework to deal with the cross-border insolvency issues. It is founded on 4 fundamental principles, as I have told you. This cooperation shall be added with coordination also. So there are 5 principles, I believe. The ILC and CBIRC have recommended incorporating these principles in the IBC itself. Now, what are the important terminologies? That is also part of today's discussion. So once we are aware about these terminologies, I'm sure we shall be able to adapt to ourselves, our knowledge, our understanding of the new law that is coming to us. COMI, we must have read it somewhere while reading through the latest updates every day we get. So what is it? This is a center of main interest. As per the model law, the recognition of proceeding is based on center of main interest. As I've told you, there are 4 principles. So one can remember them easily. One is recognition, one is the access, one is the cooperation coordination, and one is the relief. So recognition is the first principle. Recognizing, yes, some proceedings are going on. तो वो कैसे recognize होता है? On what basis? So most important aspect is COMI. On this, committee is also based on this. We'll do that when we'll reach there. Center of main interest. How that center of main interest is recognized and how on this basis COMI is established and proceedings are recognized. Okay, so COMI has not been defined under model law, but is usually interpreted as the location of an entity's key operations and assets. Most important are the operations and assets. But in case there is no information available and supporting points, support system available and information is not available, then initially the COMI can be uh, taken as the registered office address. Whichever jurisdiction the registered office is, that shall be considered as COMI, but that is a weakest test to find out COMI. So COMI का सबसे बड़ा test होता है assets, operations, people in charge of the management and affairs of the company. The statute then classifies them into foreign proceedings and foreign non-main proceedings. So COMI का establishment इसलिए important है because wherever the center of main interest shall be, वहां का जो insolvency proceeding होगा, that shall be considered as a foreign main proceeding. And whichever country shall have jurisdiction over the foreign main proceedings, the other shall be called non-main, and main वाले को सभी लोग support करेंगे. That is how the model law works. It says one country's law shall be supreme. In each case, COMI shall be decided. On that basis, foreign proceedings shall be recognized, and other countries' rules, regulations, and procedures shall be diluted to give effect to the more superior law, which shall be taken up as the law applicable to the country where main proceedings are recognized. The country where the proceedings are taking place will recognize those proceedings as foreign main proceedings if the COMI of that debtor is in that country. Okay. Conversely, a foreign non-main proceeding is a proceeding that occurs in a jurisdiction where the debtor has an establishment only. So one is COMI, one is establishment, one is main proceeding, one is non-main proceedings. Now, what is foreign proceeding? A collective judicial or administrative proceeding in a foreign state, including an interim proceeding under a law relating to. So let me tell you, judicial proceeding means at the level of, for example, if we talk about IBC, so at the level of NCLT, that shall be considered as a judicial. Administrative is whatever is done by the RP or the liquidator in-house, that is an administrative proceeding. And interim proceeding is maybe the pre-pacts, right? So those are the interim proceedings. Under a law relating to insolvency or adjustment of debt, in which proceeding the property and affairs of the debtor are subject to control or supervision by a foreign court for the purpose of reorganization or liquidation. So that shall be the foreign proceeding, and that is further divided into the main and non-main, as I've told you. Foreign representative may seek recognition of a foreign insolvency case according to the respective laws, like it is done in Chapter 15 under the US insolvency laws. The court stipulates that in absence of evidence from the contrary, the debtor's registered office is presumed to be the COMI. So that is the last and the weakest test, as I've told you. Main and non-main proceedings, how they have been defined in the model law. We have seen the definition. Now, what does this distinction, how does it help? It determines the level of control exercised by a jurisdiction and the type and extent of relief the NCLT may grant in foreign proceedings, right? So which country shall have the jurisdiction over the combined insolvency process being run or concurrent insolvency proceedings being run in the two countries, and the kind of relief that may be granted by the court ultimately. The crucial distinction between the two frameworks is the extent or judicial discretion afforded to the courts in determining recognition, right? So there is a discretion with the courts, including to NCLT, to decide to determine COMI and the foreign main proceedings. This has a significant bearing on foreign creditors, legal predictability, and treatment thereof. Person as is defined in our law. In IBC itself, the rights of a foreign creditor, IBC keeps the India creditors and foreign creditors on the same pedestal. And under the provisions of the Act, any of them can initiate insolvency proceedings against the debtor or can be a part of the ongoing proceedings. This is achieved by having a wide set of entities covered under the definition of term person as defined in the code as per section 323. A person includes person resident outside India, hence allowing them to be either financial or operational creditor for the code. So they are allowed to file an application for initiation of insolvency in India already under IBC. How this is taken care of in the system otherwise, other than IBC, like we have seen in the CPC, but that also requires prior reciprocal arrangement between the two countries, the kind of bilateral agreements that we already have. The countries with whom we have, then only those decrees and judgments are recognized as the judgments applicable to India. Then similarly, FEMA and income tax also have a bearing on the proceedings that we are going to have in the cross-border insolvency. Let's see how they have it. The insolvent debtor has assets in more than one jurisdiction. Then, where some of the creditors of debtor are not from the jurisdiction where insolvency proceedings have been filed, if the creditors are from outside country, then. So under such conditions, these two also become applicable, and thus cross-border insolvency under IBC will have to take care of these conflicting situations as well. So what is the proposed framework right now? The recognition of the foreign insolvency proceedings as well as the applications from foreign jurisdictions seeking cooperation in Indian proceedings. Another recommendation is being contemplated to make it to PGs as well, which is, I'm sure, already there because Section 234 and 235 already take them into account, and individuals are also taken up. The proposed framework has a potential to further strengthen insolvency laws and its image and its ranking in the ease of doing business, because that includes the exit also. It will build capacity, empower the IPs and creditors to access the assets outside India, trace avoidance transactions having cross-border implications, and achieve the core objective of value maximization as envisioned in the IBC. What is the situation right now? Ministry of Finance expressed concerns and highlighted several issues that may arise on account of ad hoc nature of India's cross-border insolvency framework, in which we are subsisting at present, and opined that there was a need for clarity regarding the extent to which an insolvency administrator may obtain access to the assets held in the foreign country, the priority of payment between local creditor and foreign administrator in respect of the local assets. That has been a problem. The companies are already facing this problem. Indian companies, if they have assets lying there or if they have creditors over there and our creditors are also there, so which creditor shall get a priority in payment? The recognition of claims of the local creditor in a foreign administration, recognition and enforcement of local securities and taxation system over the local assets where the foreign administrator is appointed. Indian cross-border insolvency, as I told you, deliberations are in the final stages to enact the cross-border insolvency law based on the model law given by the UNCITRAL. The cross-border insolvency regime in India will provide for an avenue for recognizing foreign insolvency proceedings in India and vice versa. Although it's a matter of time, before India adopts the model law, it's important to examine uh, whether there remains an independent basis in addition to the need for recognizing and providing assistance to the cross-border insolvency proceedings in India. So key questions again are the type of structures that are likely to trigger the cross-border insolvency provisions. As I have already seen, we have already seen them. The four key elements: access, recognition, coordination, cooperation, and relief. So I always consider fifth one is as the relief which we seek. The sequencing of domestic and foreign insolvency proceedings of a debtor, which one shall take a priority, which claims shall be priority, and which claims shall be, which assets, access of the assets shall be given to the foreign administrator or not. So these are the key questions that still remain. What are the key principles in the UNCITRAL model law that I have been harping upon and why they are important? Let's see. The principles are given under the Articles 9 to 12. One is, the first one is the access principle. So this grants the foreign representatives the right to directly access local courts without needing to meet the, just a minute, the strict procedural requirements imposed on the foreign parties. So that means the access shall be given to the foreign RP or liquidator. It simplifies the process of initiating or intervening in local insolvency proceedings. The foreign representatives can directly seek remedies for cross-border insolvency matters, but do not gain broad legal authority within the domestic legal framework. Their rights are confined to what is essential for handling the debtor's assets. It authorizes foreign representatives to participate in the domestic insolvency proceedings also. It ensures non-discrimination by allowing creditors to lodge complaint in the domestic insolvency matters also. They are treated equally with the domestic creditors subject to national rules on claim priorities. So like we have priority of, we don't have any priority in accepting the claim, right? But some countries do have. So claim priorities, payment priorities, access to the assets, all that shall be harmonized. Second is the recognition principle. It follows the establishment of reciprocity, of the most fundamental requirement. A foreign representative may file an application before the NCLT for recognition of a foreign proceeding. Akin to the model law, our draft also provides two main proceedings, two foreign proceeding, foreign main and foreign non-main. This categorization is determined based on the principle of COMI. The model law establishes a process of recognizing foreign insolvency proceedings. It distinguishes between the two, where the main business is located and where the significant assets are located. Recognition ensures that foreign proceedings are given due respect and legal effect within the domestic framework also. The relief principle. Now, this is also important, and this is flowing from the letter of request as we talked about under Section 235 of the IBC. Courts may grant urgent interim relief before formal recognition. That is an urgent relief if we can see, if we are seeking that, if the RP or the liquidator or the BT or the administrator is seeking such relief during the recognition process, if even if the main proceedings are not yet recognized as the foreign main proceedings. It can ask for staying the individual creditor actions. It can ask for freezing the debtor assets, suspending the disposal of assets. There can be certain automatic reliefs which immediately come from the point of recognition itself. It includes suspension of creditor actions and enforcement proceedings, protection of the debtor's assets from transfers or encumbrances. This is similar, somewhat similar to the Section 14. The courts may provide additional discretionary reliefs also, such as turning over debtor assets to foreign representative. This is quite difficult. I don't know how many times this must have been done, but these reliefs are subject to the discretionary powers of the courts. Coordinating asset distribution between the jurisdictions and safeguarding the creditor and debtors' interests. The cooperation principle. The domestic courts must cooperate with foreign courts and the representatives thereof. Modes of cooperation can be direct communication, coordinating hearings, issuing orders or decisions that complement foreign proceedings. So कितना अच्छा लगेगा ना, two courts talking to each other. Ki before hearing you, we shall talk to our counterpart, the other judge sitting in the other country. So we'll discuss and then we'll come back to you. So that is how the courts shall work, or they are working already in some parts of the world. Outlines practical ways to achieve cooperation by appointing maybe a person or authority to act as a liaison between the courts, approval or implementation of coordination agreements, that are the protocols. We also achieved one protocol in Jet Airways matter. You know, has anybody heard about the Jet Airways ka matter? What all we achieved in that?
Related to Netherlands and or something.
Yes. So,
I vaguely
although
remember.
it has ended in liquidation, but we have a lot to learn from that RP, what all he has achieved during this CIRP process itself.
I think we have not implemented their order.
Yeah, that is not a point of discussion here. I'm just asking about how they achieve the coordination, communication, cooperation amongst the two countries. So they also reached up to a level of writing down a protocol for the two countries. It is very interesting to see what all they have achieved. We'll do that in today's presentation itself. Let me show you where we reached, even in the absence of the law, which is there internationally, but not there in India. They could achieve, and they recognized Indian proceedings to be the main proceedings. Okay. So, one person or authority, and second is the agreement between them. So, some sort of protocol that hum aise karenge, how these proceedings shall work in tandem. Require domestic insolvency practitioners to cooperate with the foreign representatives handling the same debtor ka insolvency. So cooperation here may involve information exchange, assets, claim proceedings, creditors, etc. Joint strategy for asset recovery, harmonizing plans for restructuring or liquidation, as the case may be. Now, next is this was a cooperation, this is the coordination. So what is it saying? Local insolvency proceedings can be initiated even if a foreign proceeding has already been recognized. However, such proceedings must be limited to local assets or business operations unless a foreign proceeding is a non-main proceeding. So whichever is a main one shall continue full-fledgedly, and those interests shall not be affected by the non-main proceedings, but both of them can continue simultaneously. Only thing that the non-main proceedings shall be limited to the local assets and local operations. If both foreign main proceedings, if both main as well as non-main exist, then the relief measures granted under the main proceedings should be aligned with the local ones to avoid conflicts, and courts ensure decision in the non-main respects the overall global restructuring or liquidation strategy as has been decided by the people involved, representatives of the main proceeding. So that will have to be given due respect. Creditors who receive payment in a foreign proceeding cannot claim the same in the local proceedings, prevents double recovery by creditors, and ensures fair distribution of debtors' assets. Cross-border coordination is encouraged, but local courts retain jurisdiction to prioritize local rules and protect local creditors if that is necessary. As a general rule, a corporation is resident in a country where its central management and control are exercised. The rule applies to foreign companies and need to be distinguished from the place of incorporation and place where central management and control are being exercised. In principle, a corporation will exercise its central management and control from single place and will have one residence. Exceptionally, there could be multiple residences. In those cases, there is a division of power over the various residences. The connecting factor is for jurisdiction in relation to main proceeding is the center of debtor's main interest. And that shall be, as I've told you, the central management and control of the company from where it is being done. Now we have reached to a point where we have understood what all needs to be done in our IBC. Although I have only touched upon 5 basic principles of the model law, which are already there in our part Z. and the procedures laid down thereunder. I have not gone into details of intricacies thereof. Once that is established, once that is there for discussion, from that point onwards, you can delve into that, and you can maybe try and understand how new amendment is coming to us. So what all amendments are foreseen now? 235 and 234 and 235 may be amended. Section 60 may be amended to allow transfer of domestic proceedings to the foreign proceedings, to the foreign courts also. The IBBI may amend the inspection and investigation power uh, to to have penalties against the foreign representatives also. That is how I think about it. 196 may be amended to include regulation of foreign representatives also. Additional rules and regulation making power will be needed to be incorporated in 239 and 240. The 11th schedule may be amended based on decision to amend 375 of the Companies Act, which is winding up of unregistered companies, and preamble to the code may be amended to reflect inclusion of cross-border insolvency. So, first cross-border insolvency case was Jet Airways versus State Bank of India. Yes. Is someone saying something?
No.
Okay. So till now, I hope it is clear. Are we there?
Yeah.
Yeah. Anyone else wishes to say something? If it is clear, have I made sense? Kramaji, Kram.
This is Ramakrishnan, right? So my name appears as Rama.
Rama.
Yeah, my name is Ramakrishnan. Yeah, I understand. So far, no issue, madam. You can go ahead.
Sure. Thank you so much. So at least three people are listening. I can. All right. Yogeshi, is it making any sense? I'm sure whenever the draft Z shall come, we shall be the first people who will understand it properly, because we are already aware about the basic concepts thereof. Ashutoshi, you have unmuted yourself. Would you like to say something about it? नहीं तो मैं तो बोलती चले जा रही हूँ ना. I'll keep speaking then. Anybody? Nobody would like to give a rest to my throat. Okay, so let me go back and keep speaking then. So let us understand. Okay, anybody who has followed the Jet Airways ka, not the final judgment. I'm not talking about the liquidation. That has been quite unfortunate. And the liquidation of Bhushan Steel, of course, talk of the town. We are not talking about the liquidation orders. We are only seeing what has happened during those 5 years and what we can learn from that. Has anybody followed the Byju's or the Jet Airways ka matter?
No,
Anyone?
no
Only
more.
for
Sincerely
Only
to
for
say,
exam
we
purpose we have
haven't
studied
followed
it.
anything.
Okay, you have recently cleared or what?
Myself in December.
Okay, okay, all right. Chalo, let me go back and see where only important points related to today's context are there. So my screen is visible, right?
Yeah.
Okay.
Yeah.
So this was the first matter which recognized that there was such an urgent and important need for a cross-border insolvency regime of our own. NCLT faced the challenge of addressing the issue of parallel insolvency proceedings in two different jurisdictions. The tribunal also expressed concerns that allowing concurrent proceedings would cause delays and complicate the insolvency process. So this is all documented over there. So this was actually huge. I must say this is a successful matter as far as the process and understanding thereof has gone. The other part is, of course, we are not discussing that. Jet Airways registered office and primary assets were in India. So NCLT asserted its jurisdiction over the matter when there were concurrent insolvency proceedings. On 20th June 2019, the tribunal ruled that Dutch insolvency proceedings were null and void concerning Indian assets and it formally admitted the CIRP against Jet Airways under the Indian law. So that is how it started. During the first hearing, it was brought to the tribunal's attention that a month earlier, insolvency proceedings had already been initiated against Jet Airways by a district court in the Netherlands. In the Netherlands, the company had been declared bankrupt and the Dutch trustee had been appointed to manage the estate of the company. It's not about that the company was into liquidation. They call their insolvency proceedings as a bankruptcy proceeding only, and the RP was called as trustee. On an application made by the Dutch trustee, that is a foreign representative, appealing against the 20th June ka admission order before the NCLAT by its order dated 12 July and 21st August 2019 directed the RP in consultation with the COC to consider the prospect of cooperating with the Dutch trustee so as to have a joint CIRP. So that was an innovation. Some legal innovations are done in our courtrooms also, and they are really interesting because they are suitable to the Indian context. NCLAT directed the RP to consider possibilities of cooperation and to have a joint CIRP. Further, by its order dated 4th September, NCLAT directed the RP and the Indian proceedings to reach an arrangement or agreement with the Dutch trustee to extend such cooperation to each other, which shall allow the COC to guide the RP to enable him to prepare an agreement. The NCLAT allowed the COC to guide the RP and to prepare such an agreement in reaching the terms of arrangement of cooperation with the Dutch trustee in the best interest of the company and its stakeholders. So since we were the main COMI, so our proceedings were foreign, main proceedings for them. They asked for cooperation in our court and our court allowed that. But the proposed cooperation agreement had to be in such a manner that our assets are protected and the rights of our company and our stakeholders are protected, and in the best interest of that arrangement was to be prepared. The NCLAT set aside the order dated 20th June by the NCLT insofar as it related to the observations that Dutch court has no jurisdiction in the matter of CIRP of Jet Airways, that it's for offshore regional hub, and the consequential directions as given to the RP in respect of offshore proceedings. But the other part of continuation of CIRP and admission of the company into CIRP were carried out. NCLAT did not interfere with the order of admission of the application under Section 7 of the Code filed by the SBI against Jet Airways. Therefore, joint CIRP continued in accordance with IBC. The parties facilitated the proposed cooperation with formulation of a cross-border insolvency protocol. Now, this was very interesting. I found it very interesting. Following the agreement on the cooperation model, a resolution plan was submitted by a consortium led by Carlock Capital and Murarilal Jalan on 22nd June 2021. However, what have happened to that, we'll come to that later. Now, let us see what is there in that protocol and how it worked actually for us. The key agreements under the said protocol was, this protocol represents a statement of intention and guidelines designed to minimize the cost and maximize the value of assets or recoveries for all the creditors of the proceedings by promoting the sharing of relevant information amongst the parties and international coordination of related activities in the proceedings, while respecting the separate interests of creditors and other interested parties to the proceedings and independence, sovereignty, and authority of the NCLT, NCLAT, and Dutch Bankruptcy Court. In recognition of the substantive differences between the proceedings in both the jurisdictions, this protocol shall not impose on the RP or the DT any duty or obligation which may be inconsistent or which may conflict with the duties or obligations to which the parties are subject to, or that are not in the interest of company's estate represented by the parties or its creditors. Furthermore, nothing in this protocol should be interpreted in any way so as to interfere with the proper discharge of any duty, obligation, or functions of the parties, or the exercise of statutory or other powers otherwise available to a party under applicable law. So this has been made in such a brilliant manner, I must say, that they have given due importance to the local laws as well. They have given importance to their duties and obligations. They should not be inconsistent with their duties under the existing laws and powers given by their respective statutes to them. And in case such conflict arises, they can discuss with each other. Parties should coordinate with each other, cooperate in all respects. In doing so, parties acknowledge and agree that the parties shall deal in good faith with each other in the interest of maximizing value of asset or recovery for the creditors. Komi was decided that the company being an Indian company with Komi in India, then Indian proceedings are the main insolvency proceedings and the Dutch proceedings are the non-main insolvency proceedings. Coordination, communication, rules were set out. Important is, I find it very interesting that direct communication among the NCLT, NCLAT and Dutch bankruptcy court. So they used to communicate with each other and that protocol was set for their communication. Imagine. An association of nation for their mutual benefit. That is how committee is defined. So committee was followed in both the nations. Information and data sharing, preservation of record and assets, claims reconciliation के लिए rules बनाए, maximizing value of assets and recoveries, committee बनाया to maintain the independent jurisdiction, sovereignty and authority of independent courts and their powers. What was the role of Dutch trustee in the Indian proceedings? In the spirit of cooperation, the DT aims to not take any action under the Dutch proceedings that would adversely impact the interest of company or its creditors, क्योंकि हमारा कौमी था. In the event it becomes necessary for the DT in compliance of his own law or by the direction of his courts to take any decision that might adversely affect the interest of the company or the creditor, the DT shall give advance intimation of such decision to the RP. In the event a plan is submitted to the NCLT, the DT shall facilitate the submission of a consistent reorganization plan. Similar manner mein banake, which is not in conflict with the plan over here, shall be submitted with the Dutch proceedings also in order to implement the plan in Dutch jurisdiction on the similar pattern. Incorporating the payout mechanism that is included in the plan, so submitted to the NCLT for distribution of various amounts to various stakeholders. His role was further to seek inputs, notify the RP, consult the RP, and be mindful of Indian proceedings prior to any material decision being taken in the Dutch proceedings, which may include any proposal or approval of a plan of reorganization, matter related to assuming, ratifying, rejecting, repudiating, etc., of a contract, matters which are otherwise prohibited under Section 14. So in these matters specifically, he had to be very careful before taking any decisions. The COC have no role to play as the agreement reached between Dutch administrator and the RP is on the basis of the directions of appellate tribunal. In spite of the same, unfortunately, Hamari COC, being the COC, interfered with the matter and put its view to the RP, resulting into difference of suggestions at various points. The NCLAT clarified that Dutch trustee will work in cooperation with the RP of India, and if any suggestion is required to be given, he may give it to the RP. The draft of cross-border insolvency protocol clause is made final and should be treated as direction. So this is all part of the NCLAT proceedings also. They have taken this up and this was implemented on the direction of NCLAT. What happened ultimately, we are all aware about this. On 7th November 2024, Supreme Court by its judgment ordered liquidation. So we sincerely think that they could have given some maybe option for considering alternate plans or may have given some further time to the same RA and all that could have been done, but this has been done and this is not now not reversible. Another order from Singapore High Court that I think I'll take some break and we'll discuss it thereafter. This is a very interesting order and I leave it here for your consumption. You can just note down this. This is a very important order of Singapore High Court. Very recent one. This is dated, I think, March 2025. Right. So we'll do this after the break. Shall we take a break of maybe 15 minutes, Anjali?
Yes, madam. That is what usual practice.
Okay, thank you. All right.
That is protocol.
Hi. So let's go back to an important decision of the Singapore High Court and how it has helped us a lot. People are considering this to be the first matter. There have been a number of news articles that I have seen on all the wires. They are quoting it to be the first matter where Indian proceedings have been considered as foreign main proceedings, but no, the first matter was Jet Airways matter, and that has beautifully already taken care of the COMI to be in India, the foreign main proceedings to be in India, and that was interesting. So this is dated 24th March 2025. This is the most recent matter in cross-border insolvency affecting India directly. In the High Court, Compwaj Infocom Limited, that is the CIL, an Indian incorporated company, and one Mr. Jan, he is the RP, Gajesh Labchand Janji, he is one amongst us, sought, see the level of intellect that he has applied here, recognition of CIL's CIRP as the foreign proceeding under Article 17 of UNCITRAL Model of Cross-Border Insolvency as adopted by Singapore in 2018. The recognition of Mr. Jan as a foreign representative within the meaning of Article 2I of the Model Law. Additionally, reliefs under 21(1)(e) of the Model Law were sought pertinently for the CIL's assets which are located in Singapore to be vested in our IP and for Mr. Jan to be granted the power to take all actions reasonably necessary for the administration, realization, sale, and return of all the assets and any proceeds thereof located in Singapore to CIL's estate in India. So these are the kind of reliefs that he has asked for. Now, the issues before the High Court were first issue, whether CIRP is a foreign proceeding. So first was a recognition issue. Second, whether Mr. Jan is a foreign representative and whether he was appointed under the CIRP and whether the procedural requirements under Article 15 of the Model Law have been satisfied. Now, so sub-questions under these main issues were, first, whether the CIRP is a collective proceeding was held in affirmative. What amounts to a collective proceeding was considered in Accentra Holdings at Singapore High Court itself, which laid down the following prepositions. It concerns all the creditors of the debtor generally and is not instigated at the request and for the benefit of a single secured creditor. Second, a key consideration is whether substantially all of the assets and liabilities are being dealt with in the proceedings. And third, that it considers the rights and obligations of all the creditors or not. So it was held that yes, CIRP is such a proceeding that takes care of all these three. It has all the three necessary ingredients of being a collective proceeding. Second question, whether CIRP is a judicial or administrative proceeding in a foreign state, whether NCLT constitutes a foreign court as per the definition given under the Model Law, while the CIRP procedure the NCLT partly comprises members of the judiciary. It is not a court. It was constituted by a notification by MCA. However, its quasi-judicial nature does not defeat its status as a foreign court. And as a foreign court includes non-judicial authorities as well. Indeed, the NCLT would constitute a foreign court because it is competent to control or supervise a foreign proceeding. Assuming for the moment that CIRP is indeed a foreign proceeding, by now, in the judgment, they had not concluded that CIRP is a foreign proceeding. They are still at defining whether NCLT is a foreign court or not. The NCLT is the AA under the IBC and has specific jurisdiction over the CIRP process for the companies. It also exercises several judicial powers in relation to controlling or supervising the CIRP. NCLT is thus a foreign court. Once it was established that the NCLT is a foreign court, it would follow that the CIRP, being a proceeding commenced and supervised by NCLT, which is a judiciary or administrative body, would constitute a judicial or administrative proceeding in the foreign state. Whether the other requirements of a foreign proceeding were fulfilled, the judge is saying that I was also satisfied that the CIRP is conducted under a law relating to insolvency or adjustment of debt from what has been discussed above at so-and-so serial number in the judgment. The IBC is a statute which carries legal force and which relates to insolvency. The CIRP is a tool for corporate reorganization, an alternative to the liquidation. Accordingly, CIRP fulfills the 5 cumulative requirements of a foreign proceeding under the model law. Whether Mr. Jain is a foreign representative appointed under the foreign proceeding. So following the definition of foreign representative given under Article 2, Article I of the model law, a foreign representative refers to a person or body authorized in foreign proceeding to administer the reorganization or liquidation of the CD's property or affairs, or to act as a representative of the foreign proceeding. Mr. Jain is within this definition as he is a person authorized in the CIRP to administer the reorganization of CIL. Furthermore, via the second NCLT order, he was appointed and authorized as the RP for CIRP. Accordingly, I also granted recognition of Mr. Jain as a foreign representative within the meaning of Article 2I of the model law. Then recognition under Article 17 of the model law. Now, this was important. In order for the court to grant recognition of a foreign main proceeding under Article 17, Sub-Article 2, Sub-Article A of the model law, there must be a foreign proceeding which takes place in a state where debtor has its commie. Having found that CIRP is a foreign proceeding, I turn to examine the issue of CIL's commie, where its center of main interest lies. Prima facie, it would be India because CIL's registered office is in India. There does not exist any proof to rebut their presumption. On the contrary, I agreed with the CIL submission that the other factors evinced by the circumstances cemented India as commie of CIL, namely, both CIL and CIL Singapore branch are controlled from India, where the directors are based and who make the operational decisions. CIL's main assets, operations, and substantial businesses are in India, and India hosts the majority of CIL's creditors, with only one Singapore creditor's claim filed, expected to constitute about 95% of all Singapore-based claims. Therefore, CIL's commie was determined to be in India. Accordingly, I granted recognition of CIRP as a foreign main proceeding. So we were foreign proceeding and then we were foreign main proceeding. To become a foreign proceeding, it was checked whether NCLT was a foreign court. Yes, that has also been established now. So this judgment shall go a long way in paving the path for our NCLT, our IBC, our CIRP, our RPs to be established as foreign representative, foreign court, foreign proceedings in the model law, in the other countries as well. Now come to the reliefs, which are really very important, and it is up to the prerogative of the even the country where foreign, which are dealing with the foreign non-main proceedings. Even they have to consider their own local statutes, and the interests are to be protected for their own assets and creditors located in their own country. The additional relief sought in relation to the repatriation of CIL's assets located in Singapore fell under the Article 21(1)(e), which would be subject to the requirement under Article 22(1) that the interest of creditors and other interested persons are adequately protected. Right? So important is that interest of the local creditors shall be protected. While these do serve the interest of creditors in Singapore, therefore, I declined granting such relief at this stage of the proceedings. The Singapore-based creditors must be put on notice and given an opportunity to voice their objections if CIL wishes to repatriate the assets located in Singapore to its estate in India. If CIL wishes to do so, the court will convene a hearing with the participation of Singapore-based creditors. Another important point, as per the Article 6, which is Article 6 of the model law, which Singapore court had to take note of, that they said that recognition of CIRP and the reliefs ordered will not contravene the public policy, which satisfies a requirement of Article 6 of the model law. So conclusion, I granted the so-and-so OA, save that I declined to grant the additional relief for Mr. Jain to be given the power to repatriate or return the CIL's assets or any proceeds thereof in Singapore to CIL estate in India. Any such repatriation or return must be done only with the leave of the court. And court shall hear the no objection from the creditors in the next hearing, and thereafter a decision shall be taken on this basis. Right? So this has been an important judgment. It has laid down certain important fundamentals for us, like CIRP is a foreign proceeding. RP is the foreign representative, and it is a collective proceeding. Then NCLT is a foreign court. And thereafter, what was there? India was considered to be center of main interest in this particular matter, for which 5 tests were applied, and this was decided. In Piramal housing also, there were certain important issues that Honorable Supreme Court highlighted. It said that NCLAT has misdirected itself, relying on the foreign text and jurisprudence, which could not be made applicable to the insolvency regime of India, apart from the fact that such foreign text and precedents relied upon by NCLAT merely indicated that the proceeds from the avoidance application may be for the benefit of the creditors in a situation when RP does not deal with its treatment. It is well settled by this court that court should be wary of transplanting international doctrines which might have evolved as responses to the specific needs of juridical regimes. So in this case, the NCLAT relied upon certain foreign judgments for deciding on the matter of repatriation of avoidance transactions and realization thereof somewhere else apart from India. But Supreme Court emphasized that those doctrines were, case precedents were not applicable to the matters related to India, and NCLAT की काफी खिंचाई हुई है इस वाले matter में. Although I do understand, and I have read about some commentaries about NCLAT decision, which was not unreasonable, and one could have relied upon that decision as well. So this Supreme Court order is also going in the other direction, and till such time we do not have the law in place, such kind of judgments will keep confusing us and the courts in how to proceed with the cross-border problems. Adjudicative body should carefully observe international principles while applying municipal or domestic jurisdiction. So application of the international laws or case precedents should be carefully done by even the courts. So there are certain other judgments wherein the problems were identified and cross-border aspect was highlighted, and some of the solutions were applied, and in some cases solutions were not there. But one can go into details of the judgments wherever they are lying. Most of them shall be available on the IBBI website, and if you are interested, you can go through them in detail. I have not taken details of all of them. You will get them easily. In one of the personal guarantor matter, the Delhi court, in case of so-and-so versus Bipan Kumar, ordered for preservation of personal guarantors' assets in India against whom bankruptcy proceedings were initiated in Japan. In the instant matter, Vipan was the personal guarantor of a Japanese shipping company against the loan advanced by the bank. On default of repayment of the loan by the company and the PG, a bankruptcy proceeding was initiated in Japan against Vipan. An investigation revealed that on the expectation of such proceedings, Vipan had transferred his 2 immovable properties that he owns in India to his brothers. So this to hamare yahan bhi it happens. The administrator of Japan filed a petition in the Delhi High Court to declare such transfer as void and to recognize the administrator's right to administer Indian assets as part of the proceedings which were happening in Japan. The High Court allowed the petition of the Japanese administrator and rejected the contention of the defendant that execution is barred by Section 44A of the CPC. Court also observed the importance of recognizing such foreign proceedings and cooperation with the foreign courts in view of treating Indian and foreign creditors equally. So this is also a remarkable judgment, and the Delhi High Court has again set a standard in international system of law, stating that they have cooperated and they have extended maybe given the relief what the administrator was asking.
But
Although Singapore,
one doubt is whether we have that kind of relationship agreement with Japan.
no, we don't have, but the Delhi High,
Bilateral.
no, we still don't have.
But are we? Then why should we consider their risk? Suppose if we start and they don't consider,
Yeah.
why should
So
we accept
that's
when
what
they
I was also
initiate the
saying.
PR?
Singapore High Court has not accepted, and we have accepted the PG matter. But since this was a clear-cut violation of law as per the Indian avoidance transaction regime also, as we understand that just prior to the insolvency or just prior to the commencement of insolvency, our avoidance transactions also apply over there in that period. Similarly, in the bankruptcy of the PG matters also, in the bankruptcy of individuals, also this investigation is allowed. So had this matter been happening in India, the same transactions would have got highlighted in the avoidance transactions. So based on that, considering that actually those transactions were void and the bankruptcy trustee, that is the administrator under the Japan bankruptcy laws, he would have a right to realize that money, which he has unduly transferred just to save upon.
And this fellow has not gone to Supreme Court.
Not yet.
Okay.
So देखते हैं विपिन जी क्या करते हैं. How would he save
This is
the?
of which year? This is very recent one.
This is very recent one, yes.
Mhm.
Other IBC cases are also there. I have just listed them. That in the SEL manufacturing, a CD undergoing insolvency in India was able to access the assets in US. The professional has been granted rights, power, protection, privileges, and immunities of a trustee in a bankruptcy in the US. In the matter of Messrs. Stanbic Bank Ghana versus Rajkumar Impex, the NCLT Chennai admitted the petition of a creditor whose ordinary place of residence was Ghana for initiation of CRP against the Indian CD. In the matter of Mercury Bank Limited versus Shilpi Cable, ये तो बड़ा famous है. The Honorable Supreme Court observed that a foreign supplier can be operational creditor, and the same is established from the reading of definition person contained in 3 subsection 23 as including persons residence outside India together with the definition of OC contained in 5 subsection 20. In the matter of Usha Holding, the NCLAT looked into the question of AA's power to examine legality of a foreign judgment, and it was held that AA has no jurisdiction to decide the question of legality or propriety of foreign judgment, and any exercise of such power by it will be a nullity in the eyes of law.
But this is giving another doubt. This Jet Airways, NCLT has formulated all the protocols and that.
No NCLAT.
NCLAT, TK, NCLT or NCLAT. But what jurisdiction they have? They have the competent authority to do the such kind of things with foreign.
The Dutch trustee appealed against the admission of CIRP and asked for certain reliefs. So NCLAT applied the principles of model law over there and allowed him to, they did not stop the CIRP, but they did allow him that your CRP and our CRP shall continue simultaneously. And in that proceeding, India's CIRP under IBC was considered to be the center of main interest and the foreign main proceedings. And he shall not take any decision without consulting our RP, and RP shall.
That is all fine, madam. But
specifically, and those were never appealed against, and those were taken as a substantial positive step in this direction, because that was totally in the direction of the model law, right?
But is there at least is there any provision in the IBC that in case of any issues which are not covered under IBC, the UNCITR can be considered for giving judgments. Is there any such provision
They
in?
have exercised their inherent powers here, sir. They did
Acha,
have they did have power to address the issues related to IBC, and someone has appealed against the CIRP. So they have just decided in the best suitable manner as per the international standards, though the model law has not yet become applicable to India, but it is applicable to most of the other countries which are part of the UNGA. So I think that has been the best they could have done to
yeah, they did a good job, but I don't know whether they
yeah,
have
but
the
technically
jurisdiction.
you can find faults in it. I
At
understand
least,
that.
if at all it is to be taken, I think Supreme Court has to take.
Yes. And if somebody's interests are getting hurt, then they would have gone to the Supreme Court. I think some appeals must have gone there because हमारे यहाँ appeal के बिना survival नहीं है कुछ लोगों का. But
Similarly, in the Japan case also,
have been certain
their
appeals.
moratorium cannot be, I mean, permitted here. They should have come through Supreme Court to impose mortality under Section 14 of IBC in respect of.
That is what this in this Usha Holdings also, na, NCLAT said that this implies that only a civil court or high court can look into the legality of foreign judgment. So it is still not clear, you know, which court shall decide what, whether we have jurisdiction or not, whether NCLAT did it correctly or not, in the best technically, whether they were correct or not, as per the IBC rules and regulations, whether they were correct or not, whether NCLAT rules, they must have had some powers, inherent powers under
The
NCLAT.
inherent powers and Article 142, I think they are akin.
Yeah. So, but whether NCLT has jurisdiction, they say in Usha Holdings, they are saying NCLT did not have a jurisdiction to decide about the legal questions involved in the foreign judgment. So, problem lies in inconsistent orders by various benches and various courts. Problem lies there.
Contradictory.
Yeah. So, what can we conclude here is that there is a need for having a robust framework addressing all the issues pertaining to this. Even the model law is not independent of its own shortcomings, but one has to customize and find out the best way possible for adopting to the same for Indian context. And there are challenges, as we have already seen. The IBC has no instrument to restructure firms involving cross-border jurisdiction. Cross-border insolvency law aims to ensure Indian lenders have access to overseas assets also. And they can get support of foreign jurisdiction to bring defaulters' asset under the ambit of insolvency resolutions. Some people also say that UNCITRAL model law may not be sufficient to deal with the cross-border cases, as only 60 countries had adopted it so far. What about the assets are situated in the other countries where model law is not applicable? So there the problem shall be similar to the problems like we are having and the countries are having while dealing with us. So those problems must be of similar nature. Principle of recognition facilitates acknowledging the court proceedings. It helps in minimizing delays. It enables the parallel and concurrent proceedings, but it grants access to the foreign creditors and debtors the right to participate. Official sources say that the government will have to necessarily sign bilateral pacts with various countries. And important is that they may have to compromise on certain points so that they get some trade-off in this law, you know, in the respective bilateral agreements. While we are so late in signing of them, I sincerely agree with all those writers who believe that we will have to have some trade-offs and we'll have to compromise, or maybe some significant policy amendments shall have to be made in the trade bylaws with them. Solutions could be the government may enter into bilateral treaties as fast as possible with each other to strengthen the ecosystem. If the assets of borrower undergoing insolvency in foreign jurisdiction is to be entrusted to a foreign representative, then such assets would not only be entrusted upon the NCLT being satisfied that the interest of domestic creditors is sufficiently protected, like it is already provided for in the model law, that whenever it will be adopted by a country, the local countries' creditors and the company's interests shall be taken care of. The government is also aiming to redefine and strengthen the out-of-court processes for bankruptcy resolution before introducing cross-border. So pre-packs and the creditor-controlled resolution process is being focused upon. And I think because of those amendments in the mind of government, the cross-border and group insolvency as a larger subjects are not being floated in the market as yet. The idea is to make the processes more efficient and robust so that the need for involvement of courts could be reduced and the pace of resolution is quickened. I think that is it in my presentation today. I have been speaking at such a speed. I don't know whether you have been keeping a
No,
pace.
but say one thing is, madam, suppose if we write our own law, if we are going, you said that we are going to finalize in the winter session. Then what sanctity it would have if other countries do not consider that is a value?
No. They will have to.
It-
Because we are part of UNGA. We are member of UNGA. They will have to consider that. ऐसा नहीं होगा. We are adopting model law anyway. We are under obligation to adopt that. We are late and we have to only customize it to make sure that whatever
Indian
customizations we are making is to protect the interest of local creditors and local the company's interests, etc. In case they are, even if they are non-foreign, foreign non-main proceedings, even then their interests are protected. That much leeway is given in the model law philosophy itself. So, any questions?
One more I will ask, madam.
Yes, sir.
Suppose some personal guarantors, they are absconding and they are staying away abroad after becoming insolvent here. So they have built up assets there. Suppose if we want to have access or we want to have the information at least from other countries, whom have to approach?
You will have to approach to the adjudicating authority or the correct authority, relevant concerned authority dealing with the insolvency matters in the area where that jurisdiction falls. For example, we are having an idea that he may be having some assets. We are having substantial proof that he may be having assets in, say, the Netherlands itself. So we will go to the Dutch court, whichever will be having the jurisdiction under their respective bankruptcy laws, insolvency laws. So similarly, we'll have to find the correct court where we shall apply for having access to get our proceedings recognized as insolvency proceedings, foreign proceedings, that we are looking for, we are seeking for a relief, asking for some access to the assets, or maybe repatriating the benefits arising therefrom to India for the benefit of the creditors. If we are the main ones, then definitely they will grant that.
But if IBC was introduced in 2016, and even after 10 years or 11 years, I think our country is not ready to frame act for cross-border insolvency. So they must be having a lot of doubts, and our doubts are very silly.
Yeah, but see, we
But
are
the
new.
law in different countries is different. So everything has to be considered before we draft something.
And our domestic law shall be considered. So we shall be taking any moves, making any moves under our law. Whatever cross-border insolvency shall be applicable to us. And thereunder, if we are moving correctly, then they shall also consider our appeals and our requests. So this was it, because I have not flooded my presentation with too much of text and too much.
What is privacy for us? It is not a privacy for them, and what is privacy for them is not a privacy for us. So the law is totally different. So before we invoke some section, I think they have to apply their mind.
Yeah.
So that is the reason why things are taken till late.
That is why this Singapore
And
order.
secondly, only by only we go through a practical scenario, we will know exactly what are all the issues to be addressed.
Every matter, if you consider CIRPs also, here also, every CIRP brings its unique challenges. Don't you think so? Every CIRP, every PG brings his own challenges. You have to, modify certain manners in which you are conducting yourself. You have to change the communication channels and do all that. So it's it shall be much more when we will be dealing with the international players, but it shall be an upgrade for us. We shall be professionally uplifted, and those who understand the law on the right time shall be the first movers, and they shall be more confident in dealing with such situations, I think. Anything else?
Right. Actually, Mr. Vishweshwaran asked one question that somebody has swindled money and gone abroad, and we have to go and catch hold of them, right? Something like that. They have created some asset there. We have to create a charge on that, or we have to take possession of it.
So,
Does our AA give direction to their AA to issue some kind of possession letter or something like that? I'm sorry.
a letter of request is already contemplated under Section 235, right? So
Okay.
when we will be drafting an entire part for this, one part comprises of entire CRP and liquidation. You can consider how heavy that part shall be, which shall be dealing with the cross-border insolvency scenarios. And they shall be making processes and procedures and scenarios wherein we shall be able to apply for that. We shall be able to seek those reliefs. While our insolvency proceedings, for example, our bankruptcy proceeding is going on against a PG as an individual, and our proceeding is recognized as such. So in one application, like this Mr. Jan has done, he has asked for being recognized as a foreign proceeding, being recognized as a foreign representative, and thereafter he sought certain reliefs. So they have not granted relief because of their domestic rules and the model law that they have adopted already, saying that we shall hear our creditors first. So as far as the assets which we are eyeing that RPG has made over there, and so far as he has done it on the basis of some certain unavoidable transactions, then our case shall be stronger. So depending on the scenario and depending on the law in place, I think we shall be able to at least apply for the reliefs. And in the times to come, abhi tak bhi, we are not having our own model law. Still, our proceedings are considered as foreign proceedings in two of the matters that we have discussed today, right? Once it will be in place, see where we will reach thereafter. Can you think about a positive scenario around that? Because we are growing so fast. IBC is such a huge commercial law. I always consider it to be having so immense repercussions of having IBC in India, not only in India, but upon our image as a country, as an economic place of doing business in the eyes of the world. So we have created an image already. We have implemented it properly. It's only that internally we know there are some delays, and NCLT is not so equipped with taking such decisions promptly, and there is caseload. That is all administrative delay, but legally we are strong, right? So I also believe that the cross-border insolvency law shall be strong enough, which shall give us strength to apply for the same. And they will have to consider it because they are also bound by the model law.
See, before you go and make an application before AA, you must have some proof to say that this particular property belongs to this man
Yeah,
who
that
who was cheated in India.
then only, na, on the basis of doubt, तो कोई कुछ नहीं कर सकता है.
Yeah,
Even
you can't go with a doubt. See,
जी ने निकाल पाया
I'm
ना कि
doubting whether
property
this
है.
fellow is having this property there. No, we have to establish that it is in his name.
Yeah, बेनामी property तो मोदी जी
But
ने
how will
निकाल
you
पाया
get
ना.
those data? I don't know. How will you, in India itself, getting data is a big challenge.
I know it is. For the PGs, it is a nightmare. Getting
Yeah.
data is a nightmare. No
Yeah.
one has uploaded their returns. If they have uploaded, they will not share it with you. You will not get any data of any PG easily. How will you get data in the outside?
I have attended one session on PG taken by you.
Acha. Okay.
So I know the problems.
The problems. I keep collecting those problems and keep imposing them, keep proposing the solutions to whichever fora I am. So I keep proposing the solutions to them, but
Ma'am,
practically for the last 4 years, IPs are suffering a lot and they are not getting paid for the PG matters. So PG is a pain.
Yes.
the PG, I am praying, madam. I am praying, madam. I have only one PG case. Actually, it is actually it has been a month after month. One hearing is there. I am not attending it because I am not called. Also, I am also recognized. I am also not recognized because the councils are arguing. So my presence, absence, not recognized. So I
Yeah,
don't attend. And I do see the order passed by the NCLT. What happens is they postpone to next month, they postpone next month, something
yes,
like
they
that.
are doing that. And
It's
consider
happening like
the
that.
position of those RPs who have got 16 matters in one go. So आप समझ सकते हैं what pain they must be going through. It is
I'm sincerely praying to God
CIRP.
that this case is dropped. I'm praying to God. Let it be in favor of PG. So
Sir,
I am out of that.
sir, let me tell you,
Yes.
Ma'am.
in 2021, I was allotted a PG case, but I wrote to Income Tax Department and IG registration. To my shock, they sent me 10 years return.
Mhm.
So it has happened.
Ma'am,
Yeah.
even in my
only
case
thing is
happened.
that we
Even in my case it
need to
happened.
initiate action. The initial hesitancy, I think it is stopping every one of us.
No,
Now
no,
it is
it's
slowly
not
they are coming out.
because I will have to share this because when I
Mm.
wrote, only one mail I sent with my letter pad and the order. They within a week they sent me.
Mm.
And what about the properties owned by them?
The same thing, IG registration. I had 30 to 35 transactions which they sent me over a mail. But when I wanted to pursue, see, I was not lucky enough. The thing is, after that it stayed because of the other case. So only now they've only in this August they've started with PG. So I was not in a now at present I'm not in a position to pursue that because the creditors their interest has gone. Almost 2 years have lapsed. But otherwise, I have even today I have. So if at all this case goes to liquidation, now we have applied for liquidation. So I'm waiting. Yeah, sorry, bankruptcy. So I'm waiting for at least at that point of time. Let me take those information and see what the transaction. When I sent those transaction within 2 days to that particular person asking for the reasons, he said this does not belong to me at all. But after that, I couldn't. I'm talking about 2021, and now we are in 25. So at least in bankruptcy, I'm waiting. So it is not that maybe we write, maybe if today we are getting it or not, I'm not sure. But I really.
So, beyond ITRs, beyond the bank statements, I'm not sure whether we will get all the property details, etc.
Yes.
Because it is the address of the PG is changed. Many
Yes.
PGs have changed the spellings of their names,
Their names, they have no, I'm.
They are changing deliberately. The
This is the
address is not correct. The spelling of the name is not correct. You cannot Google it. Once you Google a name, Sumit Kumar, so there will be 2000 Sumit Kumar, right? Having the Delhi address maybe. So how will you find and how will you find out the property related to them? So it is a difficult task unless we have a central database which helps us. Just like the companies, we get the data on ROC. It's a huge help. Although it is not updated for the past 2-3 years, we don't get it normally. Companies stop filing their returns, etc. But in the case of individuals, we even don't get anything. So there should be a central database which should help the RPs. It should be integrated and access should be given to us on a genuine request. Government should be allowing us on the basis of Aadhaar number or whatever information they are carrying. Then what is the benefit of government carrying all that data?
Yes. So that's what I'm saying. When I sent the PAN number and then number, I was able to get the information. And to my shock, recently when I saw, I was in a Facebook, he has changed his second name.
Yeah, they are doing it. They are changing wives. They are giving divorce to their wives and giving maintenance so that their properties and maintenance is out of the excluded asset and all that. So all sort of they are having better advisors than the RPs are getting, So I have learned a lot dealing with such people. All right. So being an advisor also is a good job.
Actually, in the PG case,
Sorry.
what happens is, ma'am rightly said that income tax department, they replied to my my letter also immediately within a month because it has to go to some protocol they follow. You go and give it in facilitation center, tapal, what we call is tapal, the dispatch section. They don't react. What happens is it goes to immediately they direct you to go and meet the assistant. We meet him or her, and she or he or she puts across to the deputy commissioner for the approval. Then only it gets on the it comes to us. See, it happens within a month. I agree with you. There is a civil. If you go to a civil, it's a civil score of that particular individual. Probably you'll get some information. Like that, only I got an information saying that he has got a property in a place which he has pledged to a bank. So I went to that bank and served this notice. They said, what is the loan amount outstanding and what is the value of the property, everything they disclosed. Like that, it's very difficult in individual to get the information because there is no place where everything is getting recorded.
I appointed a detective agency in one of the bankruptcy matters. I was giving advice too. So that detective agency took all entire 4.5 months, and thereafter they just came up with no news on the assets and properties where all I directed them to. So I directed them to some districts of one of the states of India. So how can I be so sure that these much districts I should cover and I should pay for that? How much cost will that add to the entire process? And even then at the end of it, if there is no result, then so
The thing is,
when I
creditors-
try to sorry, ma'am.
they are not ready to pay. First of all, help is very much limited, and how's that I can spend from my own pocket? It's not possible. What you say is yes.
All right. If anything else on the cross-border thing, we can discuss, or else, Anjali, can we close the session? Because I think I have covered already whatever we had for the day. Brijender ji, would you like to share something? Please unmute.
Yes.
Yes.
In fact, I am new only to listen because I have not handled any cross-border case or
Nobody
this
has,
personal
sir.
guarantee case. So I was the mute spectator only, and yes, it
I'm
enriched
sure
me
it
also.
makes some sense, and the concepts are now
Very
clear.
well, very well, very well, very well,
Yes,
very well.
whenever cross-border shall hit the ground, we should be the first to understand it concept.
Certainly, certainly, certainly. Yes,
thereafter we
concept at least we have got.
implementing.
Yes, yes, sure. Very
All
well.
right. Do
Thank
we have
you. Thank
Anjali
you.
here? Anybody from the institute? I
Yes,
think
yes,
they
come.
come on 6 o'clock.
I think they'll come around 5:50 or so.
Yeah. So maybe we can discuss about the PG thing in case you have any further questions, because I love being an advisor. That is my
For
original
PG. For PG.
question. Yes.
Oh.
Madam, then you share your number. We will
Why not?
Share your number on the this one chat box. We'll definitely be in touch with you.
Okay,
Yeah, sure.
ma'am, can you suggest me? See, I told you I have the information with regard to income tax as well as IG registration. There are few transactions which they have done, and I went in person. They said you can come, sit here, get all the information you want. I will provide you a laptop. I will provide you my machine. Okay. Now,
Lucky you.
yeah, I'm telling you the truth. Okay. So how can I crack this better, at least? Because when PG came and saw me, you know what he said? Madam, I have nothing with me. He's actually he had an agency, car agency. So there is no need for him to give money to the tune of 1,000 crores and things like that. Okay. Now he says, I have no money. I'm zero now. Please declare me bankrupt so that I can be free. This is what word he used. I was literally
Declaring bankrupt won't set him free. He shall be a discharged insolvent. So there are stages in that.
but he is happy about it. He says, why? Because the way he said, you please declare me immediately so that
So he has been advised as such, because declaring oneself as a bankrupt is not an easy job.
I know.
It is stigmatized like anything.
and
You
even
are considered as
the
a criminal if
the
you
stipulated 1 year is also, I think,
There's a
very.
stigma attached to that. Yeah.
I know. But what I want to know is, using these information, how is that I can make use at the time of bankruptcy? Because at least at that stage now, I want to give some thing to those information so that at least you bring him, at least make him understand.
If you have actually got the assets named in him, you can also get all the bank balances, etc., associated with him. Of course, you must have done the research on the DIN numbers, related
Yeah.
companies where all he is associated with. You must have written to them. When the bankruptcy initiates, you have to write to each of the associations that he is working with, that they discharge him. He shall not be able to work as a partner or director anywhere. Even the shareholdings, etc., which he has, shall vest in you as a BT. And the properties that he has, you can immediately start selling them. You can assess them, you can value them, and then realization can start.
I'll tell you something. See, it's almost 3 years minimum, I'm telling. Okay. So he should have changed everything.
You must have. Yeah.
He must have done it, right? So in what way I can
Ma'am, see, there are limited powers that have been granted to us.
I know.
Let us be very honest. Under IBC, then why should we, go beyond those powers and authorities unless they grant a special power, to dig out the further detail? As I've told you, Aadhaar and PAN are linked at so many places, but we shall not be given any information regarding that.
So
So
what
these people are able to flee the space,
very bad about that.
hide anywhere. So law is as such. We are doing the best we can, but thereafter one should not be very.
See, to be very
sentimental
honest,
about
that was my first case.
Huh.
Okay. And I feel at least at the time of application of bankruptcy, let me at least convey NCLT saying that I have those many information. You please ask him to come in person to meet so that we can at least dig from him, right?
Tell you, I was also very sentimental and enthusiastic, just like you in the initial years. But now I have understood that since our powers are limited, let us exercise our authorities within those limits and be responsible for whatever responsibilities have been cast on us.
Okay.
One should not be sentimental about these people, because when it comes to your responsibility, they will check 48 hours में minutes भेजे कि नहीं.
I know. Correct.
हुआ कि नहीं.
You have said absolutely right.
है ना?
You have said absolutely right.
So whatever the best we can.
After the experience of 4 or 5 years, I fully agree with you.
Yeah. That's the best we can do,
Yeah.
Doctors are not worried about the delays happening at their place. They would never be worried about resolution getting late, applications being filed so late. And we are worried at all times regarding how to gain more assets, how to bring more returns, how to propagate the company properly so that, promote it in a best manner possible and all that. So one should work within the
same way,
the restrictive powers that we have. So it's okay.
The same way, I have another question.
We don't have any inherent powers.
We don't have actually. Restrictive powers, I call it.
Yeah.
I am a PG in another case where the bank was a home finance, okay? And they have given to the tune of 90 lakhs as a loan. And another loan within 15 days, saying that as a top-up loan, and they have given another 90 lakhs, and the purpose is for medical purpose. So I said, I cannot admit your claim. I want some authority saying that ICICI Home Finance Company Limited is eligible to give a medical loan for a medical treatment. So it came in, but in NCLT they said you need not be bothered about such things. You please
admit the claim as it is.
If you'll have to see only 3. If there is a default, loan being given, accepted. Then if that is the case, I feel
I must say that is not the correct way of looking at it. You were absolutely right in your approach, but that has been documented now. And you can never be raised any question against whether you have accepted, on what grounds did you accept. So it is okay.
Then why do we ask for proof, ma'am? And not only that, in that case, there are other 5 creditors in a queue. If I'm going to admit, he will go sell the property, he will take the money and go off. So at least if 1 crore is there, I said, what is the fun in you giving within 15 days the top up money? And that top up money purpose is medical treatment.
So
Not-
that also have been some four grounds only, must have been.
Madam, whatever information she got from the income tax authorities and the registrar office, I
Hmm.
think she can share with the creditors who may put their efforts also to locate the asset.
Sir, let me tell you, that is the thing with bankers. For these 3 years, I've been asking simple question. Please let me know the account maintained by this particular person and his wife in their individual capacity. Till no one has given me the information.
And when I meet the bank officials, I ask about, see, I have sent an email to this email ID. Then they laugh about it.
I
They
know.
say, oh, this email ID, hundreds of people are looking at this email. So our inbox is full of you people. We do not have time to look at it. So this is the attitude that they have.
So what can we do?
No. I think instead of approaching the branch, I think it's better to
Which
the centralized database
they
will be
having
there
an
at some
account?
point.
Sir, sometimes you don't know the branch
If
only.
you approach the centralized database, I think they may be able to, filter the things and give you the information.
Okay, sir.
Certainly,
Maybe
Branch
I will do
people,
that.
branch people, I think they generally have a very limited knowledge about any of these issues.
Sir,
Oh.
all the bankers have access to the central database with the PAN number. They can find out with the name.
I know,
Name
I've seen
number
the PAN
combination is
number.
unique. You know, names can be many, but name PAN number combination is unique. They can
Only
also
one.
find out the bank accounts maintained by
Or
that person.
even a mobile number also, I think they will be able to
Yes.
trace.
No,
Yes.
sir, with PAN
They
number.
are not
if
taking
with-
any means for
with
that.
PAN,
PAN,
mobile, Aadhaar, I think they are. It is
No,
better.
my question is, with PAN number and name, if IG registration can give information, why not the creditors themselves?
Creditors at the branch level, I am sure, madam, they can't.
I know. I will write to central, maybe, sir, or maybe I
You
will
find
take
out where the central
Legal
database
ID, whichever
resides.
IDs they
you
have
can-
NCLT written in that or so and so. Those
Oh.
IDs, people might help. Chaliye, if we don't have any further questions,
But
I
you
will.
have created a lot of interest in cross-border insolvency. I think this is the
Yeah,
first time. This is the first time we are hearing about cross-border insolvency,
that's
and
good.
this is also one area which is to be explored.
We have not tapped at all.
So I'm
Okay.
sure my speaking has been useful and we'll
Yeah,
be.
it's
Very
definitely.
much, very much. Thank you so much.
Thank you so much. And Institute will start searching for all of us and we'll all be gone. Shall we write on the chat or what?
I think
Yeah.
We can call her, but do we have her number?
Yeah, I do have.
Anjali, madam, na?
Yes. This is first time in my history that I've been speaking at such a speed, and I'm habitual of taking 2 hour sessions now, and
No, we didn't.
happened with me. I'll have to elaborate this presentation a bit further for the 3 hour session.
இங்கே நிக்க வேண்டாம்ல பக்கத்துலயே.
Okay, let her come back. Meanwhile, anything else we wish to discuss?
Let us see. She's not responding.
No. Okay, let us run away and let us see when they find us. I'm sure we all will be getting the hours.
Yes.
Thank you so much.
Thank you so much, ma'am. Thank
for
you.
being there. All right. Bye.
Thank you.
Thank you.
Hmm.